Right now they're overpaid and they want to be taken back home. Whatever it mama las matachulot kay bachuta santosi takano.
ስለዚህ ወረቀት ላይ ያጠፋነውን ጥፋት ጽፈን ሰጥተናል። ስለዚህ የሆነ የሚያደርገው ነገር ያድርግልን። እኛ አቻ
You're still there.
Yes, sir.
For this in September,
One year and 5 months. I don't know me anything beyond.
Join us about you. We'll talk to you.
August and 25th of August.
25th and 28th, Johannes. We are trying to squeeze, we are trying to hear you as soon as possible. We are fixing must work. What is he saying?
Yeah, I will not come back. Criminal case number E048-23, Shida Jacob Mukunji.
Yes, there are compelling reasons not to be released. It is apparent from the wording of Article 49 of the Constitution that Kenyans, when enacting the Constitution, deliberately enactment. The only exception, the Constitution. The article prescribed under statute, let me not read it. It says the state or a person seeking to justify a particular limitation shall demonstrate to the court, tribunal, or other authority that the requirement of this article 20 of the Constitution, to adopt an interpretation that promotes the enjoyment.
My name is Kahawa. And on behalf of the residents, advocates, we thank you for the way this before.
The notice of motion dated 8 July 2025 is disallowed, and the respondents are released upon terms and conditions which were set by this court on 10 July 2025, which I would wish to restate that each respondent be and is hereby admitted to bond over 1 million at one surety of a similar amount or in the alternative cash bail of 300,000 with provision of a contact person, that the respondents shall not interfere with any ongoing investigations related to alleged offences under inquiry, and that each respondent undertakes to cooperate with investigators when called upon to do so. That the respondent shall not seek to interfere with any witness or witnesses, either directly or indirectly, during the pendency of the contemplated investigation, and that the respondent shall report to the applicant once every week, starting from 10 July 2025, on site dates as would be appointed by the applicant, and that the applicant shall indicate to this court the date when the investigations against the respondents are expected to be completed. So that is the ruling.
The nature of his work, and sometimes they have a workshop for a week or thereabouts. We had a very humble request that he be allowed, or they be allowed to be reporting once every month, so that at least he's able also to attend to other duties. And I make this request noting that anytime the IO would require his attendance or to see him or to do something, he undertakes to comply. It's only that slight inconvenience which investigations, as we were informed during the attendance at the DCI, there are some records that are being checked about the motor vehicle, and also electronic gadgets that are in possession of the DCI. And our request to that, Your Honor, is a noting
conduct the investigation, we don't end up prejudicing a hustler, as I earlier on had a colleague of mine describe one of his clients, to sustain his young family and maybe to even lose his only source of income. So it would be important, and especially if the motorcycle is not an item to be considered as evidence in this case. They can take the photographs and have it released to my client for him to continue living and supporting his young family.
That's this matter between him, Mr. Mukunji, and the two others, and the IO. It is usually on a weekly reporting as ordered by the court, but in any event when circumstances allow, the IO would be able to allow Mr. Mukunji, Mr. Ikua, and Mr. Bodia to appear at a time agreed between the parties so that we don't mess up the record.
Will be done. If you want to mention it or after?
Yes, after I mentioned it.
Just to make it very clear.
So we meet again on 26th August for progress report on investigations. The respondents to make a formal application for release of the motor vehicle and motorcycle. The respondents to report to the applicant as and when required and not necessarily on a weekly basis.
Today we were here to take a ruling on the application which had been filed by the DCI seeking to detain Mheshimiwa for 14 days for them to conduct investigations. Last time when we were before the court allowed the three people, that is Mheshimiwa and the two other respondents, to be released on cash bail of 300,000 or a bond of 1 million shillings. And they did that, they've been free. Now we were coming for the substantive ruling. And the court has rendered itself, and it has found that the application to detain the three respondents did not have merit, and it was dismissed. So the same board terms that were set last time will continue to be in place. We'll be back on 26th of August 2025 for us to be updated on the progress of investigations. The DPP has indicated to court that investigations are so far 70% done. Is only a few items which are remaining, analysis of some M-Pesa statements and analyzing the electronic gadgets. So by that time, it is hoped that the investigation will be over, so that then we know whether we are going for plea or the three respondents will be released.
Okay, had an interest, and we were presenting them together with Mr. Kumu here, and that is the position. The matter is coming up for ruling because the main concern was that these are matters which arose from a conversation and some activities which were politically related. Hence, they should not find their way in the Prevention of Terrorism Act. More particularly, they should not be prosecuted in this court in Kahawa. I think that's the main thing. And now the magistrate has given his ruling, and he has said that the accused persons, or so we call them respondents at this stage, continue cooperating in the investigations as we await for the formal charges. We are all members of the Society of Kenya, so individually we can always comment on anything that is happening in the corridors of justice. What we can say, it was very unfortunate for the Chief Justice to make the comments he made, and you see now she's trying to do some damage control, but the baby is already born, the baby is out there, and I think is incumbent upon the court to have a policy on what matters can be brought here in conjunction with the ODPP, and above all, by reading the Prevention of Terrorism Act, because it's what the Act contemplated, who will be accused under that Act. And you read that in conjunction with our Constitution, it gives you a very clear picture of who are the kind of people you should find in this court. This is not a court where you bring people who are trying to express their freedoms, people who are trying to fight for the democratic space, people who are trying to ask for good governance. They are not the kind of people you bring to this court. Because if you look at the charges that we are facing in this court, and the charges that we are likely to face in this court, there is an alternative in the what you call the penal code, that is Cap 63. But ideally, you can say this is an abuse of the court process by the DPP. This is a clear abuse of the court process by the DPP, and that's why we have approached the High Court with the petitions. In due course, you will be served with those petitions, and we want now the High Court to pronounce itself in matters where it is clearly shown that they've emanated from a political action or a political consequence. Do you charge those civilians? Do you charge those protesters? Do you charge those citizens with terrorism charges? You know that is stifling democracy, in other words. I think that's all.
Kutoka hii maneno ikuje, nimeona support kubwa sana kutoka kwa mapadri, kutoka kwa mapastors. Watu wametengeneza prayer teams, wananiombea saa 3 AM in the morning. Na mimi nataka kusema asanti sana. Niseme sitawahi hata kamwe kuachilia watu yangu. Hata nitishwe, niambiwe nini, mimi nitaendelea kusimama kidete kutetea watu yangu ya Embu, na kusimama na msimamo ambao ni wa haki. Nataka kushukuru koti kwa sababu nilikuwa nataka kukamatwa 14 days niwekwe korokoroni, lakini koti imeona ni muhimu ya kwamba mbunge aendelee kufanya kazi yake. Na pia wamesema si lazima niende kila siku pale DCI, ile kitu ambayo ilikuwa imewekwa ili nisiweze kufanya kazi yangu. Na nataka kusema asanti kwa koti. Mimi I have full confidence with the court. Na wakati nililetwa hapa ati mimi ni terrorist, nilijiuliza maswali nyingi sana. Na nikiangalia hivi mimi naona hata sababu kubwa ya kusema muda ikuwe mrefu ya kufanya investigations ni kwa sababu hakuna kitu ya kufanya investigations. Mimi sasa ndio guinea pig wa kucharge watu ambao wako na msimamo kwa maneno ya terrorism. Jina moja ambayo Osama bin Laden na Al-Shabaab wako nayo. Mimi nataka kusema we will challenge it in the court of laws za hii nchi yetu ya Kenya, na tumesimama kusema hii koti ambayo tuko hapa katika Kahawa, ambayo financiers wale waliweka hapa ni United Nations, UNODC, pamoja na United States Government. Hii koti ilikuwa ya kuhakikisha East Africa iko na koti ambayo inaweza leta wale watu ambao ni wagaidi na wanaumiza wananchi wa hii area ya East Africa. Lakini mimi sasa ni mgeni wake. Mimi mbunge wa Manyata ni mgeni wake. Ni kitu ambayo imefanya nijiulize maswali mingi sana, and I appeal kwa the financiers wa hii koti, they call the state to order, kwa sababu hii si koti ya Wakenya, hii ni koti ya magaidi. Huhitajiki amendment yoyote ya Terrorism Act, iko very clear, na ikitumika vizuri wale magaidi wa ukweli watapatikana. Lakini kuitumia kisiasa, na ndio maana tumesema lazima tufanye kazi na koti. Na nimeona CJ Koome jana ameshtumu quotation ile ilikuwa imewekwa na ODPP ya kusema kwa sababu ulitaja ati ndio sababu tunatumia hiyo kucharge watu na terrorism. I think it's important to know that tungesema kila kitu inasemwa huko nje itumike kisheria, hata watu wengine saa hii wangekuwa naenda na risasi kwa mguu, kwa sababu ilisemekana tupigwe watu risasi. So we can't be following everything yenye inatajwa na inasemwa. But at the same time, I am happy with that clarification kutoka kwa Chief Justice. But we are coming back to the courts for interpretation ya kusema maneno iko na maana gani. Na tuseme hata ni moja kukua ulikuwa kwa maandamano, lakini ukiwa kwa barabara tena, hiyo sasa ukue gaidi, hiyo nayo ni maneno ingine different. But we'll prove that in the court of law. Mimi nataka kusema asanti na Mungu awabariki. Neno ya kuongea, ni vizuri watu kuongea, lakini zile vitu zinaumiza wa Kenya si vitu ambazo hazijaongewa, ni vitu ambazo zinajulikana kutoka wakati kumekuwa na vurugu wakati wa finance bill hadi saa hizi. So nimekuwa nikiobserve Raila Odinga, nimekuwa nikimuobserve vizuri. Nimeona sasa wamefanya broad based government, lakini sasa anachukua microphone anaongelesha wa Kenya. Lakini hata akiongea kama akisema ameshtumu maneno ya kupiga watu risasi kwa miguu, tunasikia bado inasemekana watu wapigwe risasi kwa miguu. Akishtumu maneno ya abduction zinaendelea. Kwa hivyo mimi nataka kuelewa hii kitu ya kuweka watu wawili pamoja, is it working for the nation of Kenya? It is not working. Kwa sababu kama mlikuja pamoja, mlikuwa muongee na msikizane na ukapeana hata memorandum yako wakati mlikuwa mna sign memorandum of understanding as a between the two parties. Kwa hivyo hiyo maongezi ambayo Raila ana propose, it is not genuine. Kwa sababu lazima ianze kwa kuonyesha commitment ya ile vitu wa Kenya washasema na iko in the public domain what Kenyans want. Thank you very much. Asante. Thank you.